Hello, everyone. Dr. Souvik Roy from Adamas University School of Law and Justice. I'm back again. Continuation of Module 4 as discussed with you earlier. So, by now, we have discussed into multiple aspects of hurt, grievous hurt. Then we looked into the aspect of wrongful restraint, wrongful confinement, and like I promised, we shall get into assault force, and criminal intimidation in today's video. So now, as we move ahead in this module and looking into the sub-modules that I have just mentioned prior right now, it's very interesting how crimes happen. In the sense, we always think about crimes or offense from the point of view of the result. But really, how many of us think from the point of view or think like an offender, think like a criminal, as from the point of view of how it happens, how it falls into place? Not many a times we do that. So, say for instance, like I was mentioning, okay, let me put it very differently. I will discuss with you a case. I start this video lecture with a case. I'll give you the facts and then get into the interpretation of it and then move into the section, move into the laws and other things. What happened is there was a house which was owned by the landlord, obviously, and the landlord had multiple tenants who used to reside in that house. Now, one of the tenants in that particular house was defaulting or a defaulter when it comes to payment of rent. So the family, the husband and the wife, was not paying the rent in time. And there's a lot of arrear accumulated to this thing that we're not paying. So clearly, uh, the landlord wanted to remove the tenant out of the house. Very simply put forth. So as a result of which, what they did was they ensured that you know what, let us remove this tenant from the house and let's replace them with someone else. Now, the tenants are smart, so they kind of preempted and understood that the landlord must be up for something like this because they themselves know that they're not paying the rent. So obviously, it's a no-brainer of sorts. So now what happened was, uh, in order to unsettle the landlord, the tenants decided to play a trick. Now, what trick was it? The trick was such that when the landlady, the wife of the landlord, was coming down the stairs of the house, the big building. The tenant, one of the tenant that is defaulting partner, he deliberately hid himself below the staircase in the dark. Now, after deliberately hiding oneself in the dark, what did they do? They did something. So once the landlady came downstairs, this tenant out of the dark came with this kind of figurative show of the hand as if it was a pistol, it was a gun. And out of bolt from the blue, just came in front and said, How? HAOO, as per the facts of the case, with a loud voice. And suddenly, out of the dark, somebody comes. You're not expecting anyone, and with a figurative imaginative, like, hand pistol of sorts, which was no pistol, but just a gesture of the hand. And the sound of how the landlady was taken aback and was shell shocked. Immediately, excuse me, what she did was she took a U turn and staggered past. As per the facts of the case, the word staggered was mentioned, I distinctly remember. The name of the case is Jashanmal Jhamatmal versus Brahmanand Swarupanand. and staggered past the passage of the corridor, went inside the room, and then just fell on the floor, completely blackout, unconscious. Now, the question that cropped up, what offense has been committed? Now, clearly, the first part of the story is, can it be brought under the ambit of hurt? Can it be brought under the ambit of criminal force? Can it be brought under the ambit of assault? Now, this person fell. For some time, her consciousness was off, and as a result of which, the consciousness that was off, that person uh, would be like, completely taken aback, right? So it was a clear case of hurt because, like I mentioned, remember in one of the earlier videos, the introductory video to this particular module 4, pain, disease, or infirmity. In this case, there was no disease, no pain per se, but infirmity did take place. Excuse me. Also, in this regard, in this particular case, in this context, the question that cropped up, a person coming like this and showing how can it be brought under the ambit of assault? Now, here we move on to this particular chapter. Now, let me tell you one thing. Assault force, criminal force, they come in a package and one precedes the other of sorts, but need not necessarily always it will. Why do I say that? So, say for instance, it's very interesting that in today's video, we'll also talk about criminal intimidation in the due course of time, of course. Let's get one thing very straight. If somebody is coming towards you and you have a bucket of water, cold or chilled water or hot water, and you say, if you come this side, I will throw water. The person is coming, you're making a gesture of throwing water, the person is going back. It means the person who is coming, who is walking, you're putting a reasonable apprehension of fear in the mind of that person that you are about to throw water. And because that person is fearful, like it happened in the case of wrongful restraint, that, a dog which is kept outside, there is no dog in the prior video. So, automatically, what happens is that this person is in a state of apprehension that this person is about to throw water. Now here comes, if the water is thrown and falls on the person, it is called use of criminal force. Now you must be wondering, what is this? If you look into section 349 of the code, it says force. In order to understand what is criminal force, we need to know what is force first, and then we move on to what is criminal force. Now, if you look into 349, basically force talks about three things: cause, change, cessation of motion. One, you cause a motion. Two, you change the motion, going in a direction, you push and the person moves in another direction. Or person is stands still, you do something, the person jumps, moves. Cause, change. Cessation is stop. Somebody is walking and you do something, the person stops. Now, these are the three major things. Along with that, first, uh, there is this element of bodily power. There is this element of cause, change, cessation of motion, like I said, or inducing any animal to move or change motion, etc. The criminal force says whoever intentionally uses force to any person without that person's consent in order to commit such offense, or intending to use force or knowing it to be likely, again the same interplay of intention and knowledge, basically. One is intention, the other is knowledge. Knowledge is awareness of fact, intention is guilty mind or mens rea, like we discussed. Knowing it to be likely that by use of such force, he will cause injury, fear, or annoyance to the person to whom the force is used. Now, three important parameters again: injury, fear, annoyance. I for injury, F for fear, A for annoyance. Injury, fear, annoyance. Now, under the circumstance, you have to understand that when you talk about injury, fear, annoyance, and things like this, it is but obvious that there is this certain element of fear factor that goes on in the mind of an individual when somebody is about to use some kind of force or a threat per se. So here, that threat or force need not necessarily be one-to-one combat or a physical force. Please understand. It need not necessarily be a one-to-one combat or a physical force. It can also be a very clear and very simple case wherein the person is using something. Say, for instance, somebody is throwing a pencil at you. You take an evasive action. Oh, the pencil is coming. Now, when somebody throws a sharp knife at you, there's a difference. The evasive action, you will, okay, pencil is coming, I have to remove my face. Oh, sharp knife is coming, I'll remove my face. But the degree of danger that is coming your way by way of pencil and the by way of a knife are two different things. Pencil might cause hurt, sharp knife might cause grievous hurt, or in fact, even death if it strikes that vital organ or portion of the body, which may lead to death. So, therefore, keeping that into consideration, assault is basically something that will give you a reasonable apprehension. Oh, this person is about to use or about to do something. Criminal force will ensure that, there is injury or there is a fear or annoyance that will take place for sure. In assault, physical touch is not there. Criminal force, that physical touch element is available, is present. So then comes a question: is it necessary that all cases of criminal force must start with an assault? Please understand the question very carefully here. My question here is it necessary that all cases of criminal force must start with an assault? The answer to that is no. It is not necessary that a criminal force must be preceded by an assault. It is not necessary that the assault has to be superseded by criminal force. The reason being very simple. If somebody attacks me from in front of me, like this, he's threatening me. It is a case of assault that I'm about to use criminal force, a reasonable apprehension in my head. And what we call as criminal force in Indian law is basically battery in English law. But we don't have the concept of battery here, we call it criminal force. Besides the point. But now, if somebody is behind me, how will I know that somebody is already just behind me? And that person is getting ready to hit me on my head, on my skull. But since I'm looking in front, I do not know what's happening behind me, despite the person doing like this, which if he had done from in front of me would have led to assault. Then, if he had struck me or tried to hit me, I had to have moved and all, criminal force. But in this case, I don't know. Or I'm asleep. I'm sleeping and somebody's trying to hit me. So obviously, it goes without saying that, this will be a case of once I get struck, struck, then it will be a direct case of criminal force, or while I'm sleeping, direct case of criminal force without assault. But when it happens from in front, then there is assault, then it's followed by, of course, criminal force. Now, this is a very fundamental and key concept. So, in one of the important cases, I remember there was a board meeting that was taking place. Wonderful. Board meetings do take place. Now, the chairman of the board was seated, and there were members who were present in the board meeting. So, there was a certain quarrel, a verbal duel, or a quarrel that happened. And while that was happening, um, what follows next is one of the members who was at a much greater distance from the chairman was holding the meeting. He got on top of the table with that aggression that, I'm going to hit. So, there, interestingly, one important parameter that was taken into consideration was that what was the distance between the two individuals? Very interesting. Um, was the distance something that can actually lead to apprehension or fear in the mind of a particular individual, uh, or the mind of the victim, that this person is about to use criminal force? So somebody who is at a proximate distance, like does like this and about to punch, is one thing, and somebody at a distance of like 200 meters or 100 meters or 20 meters away from me doing the same thing, there is clearly a difference. Now, how will the court come to a decision? How will the court understand? How will the court be sure about the fact that, how the victim is feeling or was feeling at that given point of time when that aggression or the situation of aggression took place? That is a huge question mark, isn't it? That is a huge question mark. So, keeping that into consideration, keeping that into view, what is very important and fundamental is the fact that you have to understand that physical proximity or the physical distance between two individuals is a very important line. So, if the distance is this much, and the distance is this much, two different factual metrics, two different factual situations altogether that comes into the picture. So, what is reasonable apprehension to Mr. X might not be a reasonable apprehension to Mr. Y. Also, having said that, to objectively come to a conclusion that this is reasonable apprehension and that is not apprehension, that is also another thing. In this context, let me just little bit touch base with criminal intimidation. In criminal intimidation, when I get to it a little bit later in this video, you'll find the word called alarm, ALARM, mentioned in the provision, in the section in the law. Now, the moment you say it's a case of alarm, clearly it is to be looked into from a particular yardstick, from a particular point of view. So, reasonable apprehension, alarm also means apprehension, mind you. But the degree of apprehension, it shoots up. So, say for instance, if somebody tries to uh, put me into a state of fear with the possible hand movement of throwing a spoon at me, spoon, a silver or steel spoon of steel spoon, spoon made of steel, and another person who is about to throw a hot kitchen knife at me. So probably I'll say that spoon will be more of a reasonable apprehension, and hot kitchen knife is more of a reasonable apprehension at a heightened level, much more graver, much more serious level, for which it will be called intimidation or criminal intimidation. The degree varies, and punishment also varies. I'll come to that in a bit. Now, I shall get back to the basics once again. When you talk about assault under section 351, it says whoever makes any gesture or any preparation, you see physical touch or connect is absent here. You talk about gesture, you talk about preparation, intending or knowing, again, those two key words, intention and knowledge, mens rea and the awareness of consequence. It is likely that the gesture and preparation will cause any person, that is, the person here is victim, the gesture and preparation of the accused, the alleged accused, will cause any person, that is the victim, to apprehend that the person is about to use criminal force. In an explanation, is very clearly written, mentioned. Mere words do not lead to assault. I say someone, I'm going to kill you. You see, that is not assault, because that is not good enough to cause reasonable apprehension that I'm about to use immediately. Like, there's this element of criminal force that is going to happen. In the same breath, if you look into intentional insult, not exactly criminal intimidation, you'll find that criminal intimidation, it talks about whoever threatens another with any injury to his person, body, person, reputation, or property, or to the person's reputation or property in anyone whom is interested, with the intent to cause alarm, the word that I was mentioning a while back under section 503 of the code, the old code. The word uses alarm, or to cause that person not legally bound to do so to omit, like. So here in explanation, you'll find a threat to injure the reputation of any deceased person to whom the person is threatened and interested is within the ambit of the section. So you clearly know that when it comes to the bare reading of the statute, clearly it's well demarcated, the difference between the two. It's pretty well demarcated. And the punishment level also goes up when it comes to criminal intimidation compared to assault. Now, say for instance, once we move ahead from the point of view of assault and intimidation and get back to the basics, there was this case in UP wherein it's a very interesting case, and that will probably give you a better clarity or idea that there was this station master who used to work on the railway platform, and there was a train that was supposed to reach that particular station. Well understood, no problem whatsoever. Now, the train that was supposed to come to that station, the person who was in the train used to work with that station master at one given point of time. So they had this previous enmity. There was a previous enmity between the two, which is fairly understood. So one fine day, when they used to work together, but one fine day, situation happened and arose wherein The train was coming to that station, and the station master was there, and he was on the station, and he found the train coming, and inside the train, as it was reaching and kind of holding fort at that particular railway station, his known enemy from yesteryear stepped out of the train. Not only that, as that person stepped out, that person had this weapon in his hand, and he would, like, just sharp edged, dangling knife, sort of, which he will just, play it with the hands and all, and come towards the station master. This, with a particular certain amount of look, face to face contact, eye to eye, giving it a very kind of apprehension that he's about to use that on him. So the station master, for obvious reasons, felt very insecure, fearful, and felt that his life is at risk and pretty well threatened by the entire scheme of things. This is a classic example of a case of criminal intimidation that I was mentioning. Now, obviously, doing this with a sharp, dangling knife, it will clear, clearly cause some kind of commotion in the mind of the individual that this person might use criminal force. Then, of course, it comes within the ambit of assault, because it's a gesture at the end of the day, or a preparation to use criminal force. However, after looking into the provision of intimidation, body, reputation, property, so body is definitely one of it. It was a clear case of criminal intimidation, because in this case, the weapon that was held in that person's hand was a dangerous weapon in the eyes of the law, my friend. And a dangerous weapon can cause dire consequences, death or fatality being one of them. So clearly, it was not only a case of assault, but it was a case of heightened assault, much more grave when its structure and its nuance, version, and form. And it was decided to be a case of criminal intimidation. Now, similarly, when you talk about criminal intimidation, another possible example from a given case, again, I'll just elucidate by way of an example which will be much more easily understood or be well understood by you. So, there was this farmer who had asked for money, for lending money. And after he took the money, obviously the person who had given the money asked for the money, that, pay me back the amount, give me my money back. But as it would happen, he didn't give the money. He didn't give the money. Simple as that. Now, under the circumstances, after not giving the money, when a legal notice was sent that, my client has given you this much amount of money, you are not paying it back despite repeated reminders, please pay back the money. Immediately, what happened was, uh, the concerned person wrote a suicide note or a threat that if you ask for money further, then I will commit suicide. Now, as ironical as it might sound, as funny as it might get, but the fact of the matter is, the person took the money, and when asked to give the money, he is threatening the person who is legitimately asking for his money back, that if you ask for money, then I will commit suicide. So don't ask for the money. Now, this was again decided by the Honorable Court as a classic case of criminal intimidation, wherein a threat was posed on the individual who was lawfully asking his money back through lawful means, and the person took it differently and threatened the person who actually gave the money back, that if you take the money, I will commit suicide and you'll be responsible for my death for asking money from me. And therefore, automatically, he was extremely fearful that, what if the person dies, commits suicide? So what will happen? And the court said it's a case of intimidation, and rightly so. Now, we will wrap this video up in the next 3 to 4 minutes with the concept culminating on force and criminal force, since we are pretty much aware of the idea of assault, intimidation, difference between the two, the correlation between the two, and how it happens. Remember, for force and criminal force also, it is not necessary that you have to hand do something, or you have to do something from the point of view of physically one to one. Always remember in mind that, say, for instance, you can use criminal force even without striking or hitting the person directly. So, if you have a dog with you and you train the dog to pounce on another person or your neighbor, I'm not going into the realm of torts and nuisance and trespass or anything. And your dog does that because you've trained the dog that way. So basically, it's your act which led to that particular dog functioning in a particular way, and because of which the other person got intimidated or felt that, reasonable apprehension of assault, that the dog will pounce on this thing. That is also criminal offense. I am sitting here, my telephone, my mobile phone is kept here. If somebody comes and deliberately hits the wall like this particular table like this, and suppose it's a table, and the phone goes up in the air and then falls on my head, and I'm trying to move, then also cause change and cessation of motion. Remember section 349, force, that we were discussing. So clearly, even that will come under the ambit of force and criminal force. Or for that matter, when you talk about theft, there is this very beautiful example under section 378, that if you pull up carts and are going in a particular direction, you change the course of the direction by enticing those. So, and they're carrying some gold ornaments, etc., and they take a different course, then that also comes within the ambit of theft because you've done something to ensure that the movable property moves in a different way. So you keep the whole long story short as I wrap up this video and then you move on to your next video. Yes, yeah, this is a case wherein, that's rightly pointed out, um, force, criminal force, assault, intimidation are well interlinked with each other. The takeaway: assault need not necessarily always happen in a case of criminal force. Force is the basis on which criminal force takes place: cause, change, cessation of motion, bodily power, intention, knowledge. And there's a difference between assault and criminal intimidation. A higher form of assault, or the element of reason to believe, or reasonable apprehension, which leads to an alarm, is criminal intimidation, more grave by nature, and therefore qualifies for a bigger punishment. And criminal force need not be a one to one force, it can be through external agents as well, as long as mentally, through guilty mind mens rea, it has been done in a way in order to ensure the other person gets affected. So thank you for your patient listening. And in the next video of Module 4, the final video of Module 4, we shall look into the aspect of reputation, criminal insult, and most importantly, the much awaited topic of defamation laws. Thank you.